It's my pleasure to welcome everybody back to our Hazak at Home session here and to welcome Mark Levick um, to talk with us today. He's going to be talking about the U.S. Supreme Court, non-elected legislature, or impartial arbiters. Mark was born in Florida. He graduated from Indiana University and also got a law degree at Indiana University. After practicing law in mergers and acquisitions and tax for more than 13 years, he moved to California and now also is a teacher at Pierce College and with the Encore program and at other places in the community. He's been teaching the Supreme Court class and a sports class and a current events class, and I had the pleasure of taking a class with Mark last season, and I've signed up for this season. And I can tell you, he is an amazing, fascinating speaker. I learned a whole lot, and we're going to learn a lot from him today. So Mark, welcome. And I'll just encourage everybody to use the speaker view so you see Mark more centrally. Mark, welcome.
Well, thank you. Thank you very much. I'm glad to be here today. I had prepared a discussion of a couple of the big Supreme Court cases from last year and a brief overview of the cases that are going to be decided this year, the ones that haven't been decided. And then life got in the way, and I got really angry, and I'm really angry. Seething with rage would be one way to describe my feelings today. The rage that happens when the folks we pay to serve and protect us instead betray our trust in them and continue by, let's see, at least one case just a week ago, in killing an unarmed person in what was described as a slow motion lynching. It's understandable, of course, that centuries of mistreatment of African Americans is brought to the front and we see the social unrest triggered by killings that we really should have been able to push to the side, eliminate, reduce it at least. And I don't see any evidence of that. And the murder of unarmed people, anti-Semitic and hateful violence directed at synagogues in the Fairfax district in Richmond, Virginia. Even the St. John's Episcopal Church was set on fire in Washington, D.C. last night. All triggered in some way by one police officer's use of unreasonable force. He's alleged to have committed a murder in the third degree in Minneapolis. Who's to blame for the problems that result in what we've watched now on TV for the last several days, and for the killings of these unarmed people that almost never is punished? Well, the legislatures in all 50 states. The legislatures have not stood up to the police departments in their states and demanded constant professionalism and supervision. Those states have not enacted, by and large, laws that would assign personal responsibility to police officers who abuse their power and their privilege. In addition to the legislatures, we have continuing racism evidenced by our political leaders, sometimes at all levels of government. We see local officials in parts of the country exhibiting clear racism. We see state leaders in parts of the country, and we even see national leaders on occasion unable to hide the racism. When we add all of that up and then throw in for good measure some police unions, which in some states are very powerful, we get a system where too many people in the United States are unable to go about their daily lives confident that the police will not target them in some way. There was a little bit of good news. We saw that in Atlanta, a couple of young African-American college students were yanked out of their vehicle and tased and arrested when they had done nothing wrong. Quickly, Atlanta fired the police officers and put 2 of them, and then put 3 more on desk duty while they resolved whether rights were violated in that case. But it was a pretty clear overreaction to a couple of people who were, by all accounts, not looting, not committing any crimes. And so there is a slight advancement, a slight improvement. But it's going to take a lot more than just that, or the firing of those 4 officers in Minnesota. Who else is to blame? Well, the title of today's presentation, the U.S. Supreme Court, bears plenty of blame as well. Excessive force has been alleged against police officers since the beginning. And all too often, the courts have looked for excuses, ways to absolve the officers of liability. In one really egregious case from 1989, the U.S. Supreme Court was able to hold that officers who commit acts of violence, excessive force, their conduct when sued under federal law, the 42 U.S.C. 1983, the post-civil rights or post-Civil War federal laws that were meant to ensure that African Americans would have some recourse to the courts in case their state courts ignored them. Well, in 1984, a man suffering a diabetic episode in Charlotte, North Carolina, he asked his friend to drive him to a local convenience store so he could get some orange juice. The man walked in, but quickly left after seeing a long line at the counter. A police officer was nearby, and this officer thought it was odd that someone would enter and leave the store so quickly. So the officer followed Mr. Graham and a friend for about half a mile before pulling them over. After speaking briefly with the 2 men, the officer called for backup. The man suffering the diabetic episode got out of his car, wavered in and out of consciousness, and he pretty soon found himself handcuffed and lying on his stomach on the sidewalk. He tried to explain his medical condition, but the group of officers didn't believe him and mistook an insulin reaction as him simply being drunk. The officers pulled him up from behind, slammed his head on the hood of the friend's car, pinned him face down, an officer leaning heavily on each limb. Then they picked him up and threw him inside the patrol car. At one point, a friend familiar with his condition ran over to the scene with orange juice to help. Graham begged one of the officers for the drink. She responded, "I'm not giving you expletive." After the clerk of the convenience store confirmed nothing unusual had happened, the officers drove the man home. He was left with a broken foot, several lacerations, and what we later would describe as persistent ringing in his right ear. Little did Graham know that as he writhed in pain, that this episode would lead 5 years later to one of the most important U.S. Supreme Court decisions in modern history, Graham versus Connor in 1989. Well, as a result of that decision, when he sued under the Civil Rights Statute 42 U.S.C. 1983 in North Carolina, the courts ruled against him. The Court of Appeals ruled against him, and he sued for excessive force and denial of due process. But the U.S. Supreme Court took the case, even though he had lost. But they didn't take the case to help Mr. Graham win. They took the case to set a precedent that would live on even today, that makes it extremely difficult for those who suffer civil rights violations to get any recourse in federal court. An abomination of a decision, in my view. That's continued, however, with a multitude of cases where folks who have been abused and suffer at the hands of the police sue the police, and the Supreme Court has now come up with essentially a ruling that's added to every year or two. And that doctrine essentially says if the police didn't have notice that their unreasonable conduct was unreasonable because another officer had been successfully sued, if a court hadn't yet held that that particular conduct was unreasonable, well, then it wasn't unreasonable for the officer to use that conduct. And what will ultimately be the claim here is no police officer has yet in our society be so stupid as to put his knee on the neck of an unarmed person for almost 9 minutes. And this officer's attorney, the one in Minnesota, will claim, I had no idea that was unreasonable because a court in the United States has never held that to be unreasonable conduct. That causes me anger. Uh, we hope that states can fix this. We hope that Congress would fix this. Note that the U.S. Supreme Court here is not interpreting the Constitution. They're interpreting federal law, and in other cases, interpreting state law. And the legislatures can overrule these decisions. You don't need to elect a different president and get additional justices appointed. You don't need to amend the Constitution. You just need to get state legislatures and Congress to change the legislation, to overrule the erroneous opinion of the Supreme Court by legislation, which can be done very easily. So far, society has failed. Little wonder that the lynching that occurred in Georgia in late February, the shooting of the unarmed woman while she slept in Louisville a few weeks ago. Suspect, pardon?
I was just going to say the internet is scrambling a little bit. I don't know if you have weak internet or whatever, but please continue.
Oh, yeah, I just got a little box on my screen that said your internet connect AT&T. I need to get something much faster. But we hope that as a result of what we see this week, that perhaps legislatures can step in and modify the laws and perhaps prevent or minimize what has become a 25-year cycle, every 25 years or so on average. We see the police in many cases engage in conduct, and some other cities experiencing the awful civil unrest that we see right now in cities all over the country. Well, I'll put aside that anger. I'll mention one more thing. Back in the early 1970s, we saw Clint Eastwood. He created a series of movies once he was let out of his spaghetti western contract. And the Dirty Harry series was essentially very conservative Clint Eastwood's tome on all of the awful technicalities that the U.S. Supreme Court, the Warren Court in particular, had ruled throughout the early 1960s. Things like the Miranda warning, the exclusionary rule cases, the cases that required that states provide attorneys if a defendant didn't have the money to hire their own attorney. Well, Clint Eastwood and his conservative friends were unable to roll any of those back. But ultimately, I think Clint Eastwood and his friends may have won the larger part of the war. Remember that Clint Eastwood carried his .44 Magnum, a great big giant handgun in San Francisco in those movies, and would shoot defendants, sometimes with justification and sometimes not. Well, in the U.S. Supreme Court, since the Dirty Harry series in the early 1970s, the Supreme Court, often by a 5-4 majority, has found a way to make it very difficult for the harmed person, if they live, or their estate or loved ones, to even bring suit. Now, if you're bringing a lawsuit, you generally have a very low burden. You only have to prove your case by a preponderance of the evidence. It was more likely than not. What about when you're bringing criminal charges, and where criminal charges must be proven by beyond a reasonable doubt? That burden is even more difficult. If it's almost impossible to sue a police officer for this wrongful conduct, how likely is it to get criminal charges to stick and get a conviction? The good news is, in recent years, an officer in Chicago a couple years ago was convicted. First time in 50 years, an officer was convicted of murder for an on-duty shooting. And that officer's, I think, doing 14 years in state prison. And there have been a few other officers convicted and given short sentences but it's going to take a lot more. Treating all police officers without the same deference that they've been treated with for a long time, I think, to make some real changes. Skip ahead here. The Supreme Court, due to the pandemic, was faced in March and April with cancellation of almost all of their oral arguments. They may have argued something early in March, and then they had 2 months where they didn't take any arguments. That had me very concerned. If they don't hold oral arguments, will they decide the important cases in front of them? Now, some of the important cases of this term, let's see, employment discrimination by religious employers. I think there was a Catholic school that let someone go. I think it was a breast cancer patient, and the Catholic school let this person go and said she's an employee at will. When she sues for employment discrimination, the church says we can fire people for any reason we want. That's the whole concept behind employment at will. Another couple of cases involving the Affordable Care Act are on tap for this year. Obamacare, if that's how you refer to the Patient Protection and Affordability Affordable Care Act. Down in Texas, in the Fifth Circuit, a federal court, the Court of Appeals, ruled late last year that the mandate to purchase insurance is no more. The Republicans in December of 17 managed to zero out the tax penalty. Recall that for those who didn't have insurance, the first year it was about a $90 a person tax penalty if they didn't go to their state exchange or the federal exchange and get themselves some subsidized insurance. Or if they didn't qualify for Medicaid, they had to get insurance. Well, they didn't have to. There was a carrot and stick approach, right? You either get insurance or pay a tax penalty. When Republicans inevitably sued and claimed the Affordable Care Act, Obamacare, was unconstitutional, they held their they hung their hat on several different arguments. One of them was the Commerce Clause did not. There's no way the Commerce Clause, they said, provided the authority to the Congress to tell people you must buy insurance. But when it came to the $90 tax penalty, Justice Roberts, the Chief Justice, the sometimes very conservative ruling justice, he sided with the 4 more liberal justices and held that Congress did have the power to enact a tax penalty for failing to do something. And thus the $90, which got bigger each year, was on a sliding scale, and each year it would accelerate. That $90 tax penalty was a tax. And my copy of the Constitution, I've got my little pocket Constitution here. In here, Congress has the power to levy taxes. Enough said, said Justice Roberts. The Affordable Care Act is constitutional. Some conservative op-ed writers, conservative politicians, they viewed, even the Wall Street Journal editorial board viewed Roberts as a pariah. He was no longer one of them. They were going to kick him out of the conservative club because he didn't overturn President Obama's evil, awful Affordable Care Act. Well, Justice Roberts would get a second chance. In 2015, due to a failure of either technology or the person operating the technology, someone didn't do a global search and replace of the many, many hundreds or 1,000 pages of law. No congressperson read the Affordable Care Act before they voted on it. It was just too lengthy. They got summaries, I'm sure, by their able assistants, their staff members. And in there was a potential typo. The global search and replace wasn't performed or properly, wasn't done properly to get rid of 4 words. You could get a tax credit, subsidized insurance, if you purchase your insurance from a state exchange. Those are the 4 words. Well, ultimately, there was a compromise in Congress, and you didn't have to have a state exchange. States that didn't want to establish their own insurance marketplace could just use healthcare.gov, the one that Secretary Sebelius tried her best, but had some rollout problems. Imagine if Amazon went from 0 customers to 40 million customers in one day. That's not how Amazon scaled up. They started very small and got bigger as the years went by. Well, because of that, the Republicans said, we got you. You didn't write the law properly. And it looked as though the Republicans might have a winning argument, maybe not a good argument, but a winning argument. The conservatives like to say, we take Congress at their word. If Congress uses the words from a state exchange, they meant what they said. It turned out millions and millions of people had obtained insurance, not from state exchanges, but from the healthcare.gov, the federal exchange. So Texas and Louisiana and the usual suspects of conservative states sued. And Justice Roberts, 2015, for a second time, came to the rescue and joined Justice Kennedy, who retired after that, and the other 4 more progressive justices, and in a 6-3 opinion, held that we were too far down the line in order for a simple typo, where everyone had agreed in the Congress had agreed in that compromise that they didn't have to purchase the insurance from a state exchange; they could get it from the federal exchange. That was good enough. And so the Fifth Circuit ruled late last year, well, that tax penalty, now that it's 0, it's not there, and thus there is no requirement to buy insurance. Side note here, California, anticipating all of this, and after the tax cut bill of 2017, passed its own version of a tax penalty, and thus you now have to pay a California tax penalty if you don't obtain insurance. And it's sort of modeled on and almost mimics the federal tax penalty, which was up to $700 a person by 2017. And with no family cap, that was $700 per person, prorated by month, so you didn't have insurance. The California law is about $700 a person, $2,100 or so per family as a cap, so that it's not quite as punitive. And with $2,100, you can certainly obtain some Affordable Care Act insurance from your subsidized marketplace. Well, twice Justice Roberts has been the savior of Obamacare. Will he come to the rescue a third time? We'll have to wait and see. The Supreme Court took that case, but they're not going to decide it before the election. They're going to hear the arguments next fall. And since their term doesn't begin until October 1 traditionally, it's unlikely, very unlikely they would decide that before the election this November. A couple of other cases are on the way. The deferred action of childhood arrivals, DACA. The regents of the University of California and the NAACP have both sued President Trump and his administration, trying to prevent the unwinding, the termination of DACA that allows several hundred thousand, 600,000 or 700,000, the numbers differ depending on whom you listen to, that allows them to stay in the United States. These are the people who were brought here as children by their parents from other countries, and thus they weren't active participants in themselves being undocumented immigrants. They simply followed where their parents took them. Back in the President Obama time, President Bush, in fact, had 8 years in which he wanted a deal on immigration, couldn't get it out of fellow Republicans. President Obama spent 8 years trying to get a deal out of Republicans on immigration, was unsuccessful. President Obama eventually just signed an executive order that said, we're not going to deport these individuals. Republicans, of course, sued and said, this is terrible. You don't have any authority to do this. I'm unclear as to whether the president has the authority to do that, but I do know from that Census Bureau case from last year that if the president tries to do something, he'd better be on firm ground with dotting the I's and crossing the T's, because courts will step in and prevent arbitrary actions by the president. And that's why there was no question on this year's census as to one's citizenship. That was, of course, hoped for by by the president and some of his appointees. The Census Bureau itself had already found, researchers had determined, if that question's on the census, that will depress turnout. It'll depress response rates. And the assumption was the people who would be afraid to respond and wouldn't respond would be those folks who would tend to be immigrant families, where some of the folks in the family were perhaps documented and some were not. Those folks tend to lay low and stay hidden under the radar. They don't tend to draw attention to themselves. A couple of other cases on tap, the president's tax returns and financial records. I'm morbidly curious. I'd like to see them. Some of his statements don't seem to line up with the little snippets of the tax returns that we've seen, thanks to leaks. Rachel Maddow had a copy of an old one. And thus, I'm curious. Every president since Nixon has provided them voluntarily. This one said he would, and then he didn't. If they can be obtained by either Cyrus Vance Jr., the DA in New York, or from by the Democratic leadership in Congress, whomever. I'm curious. I'd like to just take a scan through them. I looked at Hillary Clinton's returns when she released several years of them back when she was running for president in 2015. And I'd just like to take a spin through President Trump's tax returns. Not the most important thing on tap, I grant you. Let's see, there was a recent case, and that was the religion case that concerned California. Thanks to the pandemic, I see the Hazak program's been on Zoom now for a couple of months at Pierce College. Everything's been on Zoom for a couple of months now. And religious services have been put on hold across the country in most states. Large gatherings of parishioners haven't been allowed. So in a case brought recently against Gavin Newsom, the courts had ruled against the churches. The churches said, look, we're no different than a grocery store. We're no different than all the other things that are permitted, when in fact, as Justice Roberts pointed out the other day, we leave it up to the lawmakers, to the legislatures, and to the executives like governors to decide whether attending a church service in close proximity with your friends and fellow parishioners is the same functionally, epidemiology-wise, as going to the grocery store or doing other permitted essential services. In a rebuke of young Justice Kavanaugh, Justice Kavanaugh said, let's see if I can pull that up very quickly here on my screen. It is kind of neat that I have copies of some of the more pressing things available right away. In this case, where did it go here? That may be the one. No, the next one over. The South Bay United Pentecostal Church versus Newsom. Well, in that case, Justice Roberts joined with the more progressive members. So in a 5-4 ruling, he held that, let's see if I can get to the statement. He said he was not completely clear that a violation of the First Amendment had occurred. And he gave a sort of a smack to Justice Kavanaugh, who wrote a dissent. And in that dissent, Justice Kavanaugh said it was indisputably clear that a violation of the First Amendment had occurred because religion and church services were no different than going to the grocery store. Justice Roberts noted that COVID-19 has killed thousands of people in California, more than 100,000 nationwide. Justice Kavanaugh wrote a narrative that read more like a brief filed by the church, an advocacy view, and not a judicial opinion. Kavanaugh alleged that Governor Newsom's order indisputably discriminated against religion in violation of the Free Exercise Clause. For support, the justice insisted that comparable secular businesses like grocery stores and pharmacies aren't subject to the same restrictions imposed on churches. And California had to have a compelling justification for this disparate treatment. And Justice Kavanaugh found none. Justice Roberts, though, dispensed with this and said, we trust the lawmakers, and said the First Amendment, the Bill of Rights, cannot be converted into a suicide pact, quoting a Supreme Court opinion of several decades ago, and said that it was not a clear-cut issue that a church service was comparable to going to the grocery store. After all, nobody sits down in a grocery store and spends an hour or two in worship. That was a recent decision that was from right here in California. Now, in that case, the Supreme Court was merely declining to get involved, was going to let the process play out. And in fact, that was one of Justice Roberts' justifications. The law is fluid and changing daily on this issue. As more and more states prepare to reopen their economies, fewer jurisdictions are imposing flat-out bans on church services. And in fact, here in California, the limit will be, I think, the lesser of 25% or 100 parishioners, whichever is lower. And so as long as people practice social distancing and wear masks and have plenty of Purell, church services will be allowed to happen. And the Supreme Court was not going to get involved, thanks to Justice Roberts. Ever since Justice Kennedy's retirement, there have been people saying, you know, that Justice Roberts looks like he's trying to occupy some middle ground between the two factions, the more progressive justices and the more conservative justices. It was noteworthy in that case that Justice Alito did not join Justice Kavanaugh's somewhat sophomoric dissent. Don't know why. He didn't explain why. He simply dissented, but didn't join that opinion. And in fact, none of the progressive justices signed on to Justice Roberts' opinion. It was simply a 5-4 vote as to whether to take that case, with two justices writing opinions, one on each side. But none of the other justices joined Roberts' opinion. He was merely explaining why it did not make any sense to get involved, where the lawmakers are entrusted to do good here. Well, I have a couple more minutes, and I wanted to talk about the Supreme Court and, a couple of the perceived difficulties that we have today in our very polarized society. One of them is compliments of President Trump. In 2016, when Justice Scalia passed away, around Valentine's Day, if I recall, Mitch McConnell, Senator McConnell of Kentucky, said, it's an election year, and we think the new incoming president, whomever that should be, should decide who gets to fill Justice Scalia's open seat. There was a judge that was proposed, Merrick Garland, by President Obama, and Merrick Garland was about 60, and he was a moderate. He was confirmed to the Court of Appeals in a unanimous vote. Nobody voted against him. And he was 60, which means he was a little older than the typical 45 to 50-ish Supreme Court justice that many of the Republicans have looked to in recent years. I think that the Democratic appointees by President Obama and by President Clinton trended a little older than President Trump's or President Bush's appointees to the court. So President Trump has been very successful. He got to fill the Scalia seat, not with Merrick Garland, but with Gorsuch. Gorsuch, the only Western justice on the court. At this point, over 200 federal judges who all have lifetime appointments have been named by President Trump. He's far and away more successful numerically on that endeavor than President Obama at the same time of President Obama's first term, in part because Republicans did their level best to slow down the appointments. President Obama would nominate judges, and then the Senate, with some of its arcane rules, would spend a lot of time considering and holding hearings and using their parliamentary rules to the advantage of the Republicans, so that when President Obama left office, there were over 100 federal judgeships left open. President Trump announced, perhaps with some sarcasm or facetiousness, I don't know why President Obama left me all those open spots, but thank you, President Obama. President Trump has said that multiple times. Well, if I was Mitch McConnell, I'd be saying, Mr. Trump, it was me, Mitch McConnell. I engineered that so that you would have lots of open spots. Well, is all the news from the federal courts, especially the Supreme Court, bad? And I'm going to say not every day. There is actually some good news. While we decry the polarized 5-4 opinions that we're all familiar with, things like Citizens United and other very controversial, very polarizing opinions, most of the Supreme Court's rulings are unanimous. And if they're not unanimous, they tend to be 8-1 or 7-2. It turns out that since 2000, a unanimous decision has been more likely than any other result. 36% of all decisions were unanimous. And even when you add in the 7-2 to 8-1 judgments, those make up about 15% more. And the 5-4 decisions, only about 19% of the cases total end up being decided 5-4. It turns out that they do reach a unanimous or nearly unanimous decision more often than not. One of the cases, in fact, that I wanted to highlight that I think points to some good news here is in today's immigration case. There was a case decided today. It concerned a fellow who had immigrated here back in the early 2000s from Lebanon. And he's a member of a religious order, a sect with which I am unfamiliar, the Druze religion, D-R-U-Z-E. As it turns out, Hezbollah tortures people of this religion in Lebanon. And this person on a green card wasn't a citizen, he's a green card holder. He committed a crime, receiving stolen property years ago, did 364 days in jail for this, and then the folks at immigration decided they would begin proceedings to remove him. And ultimately, his case got to the Supreme Court. He said, I may be eligible for deportation, but you can't deport me to Lebanon. I will be tortured. And there is the Convention Against Torture, to which the U.S. has signed on, that prohibits the U.S. from deporting someone to a destination where they will be tortured. They could be deported somewhere else if we can find a jurisdiction willing to take them. And eventually his case got to the Supreme Court. And in a ruling released today, this morning, Justice Kavanaugh wrote an opinion in which Roberts, Ginsburg, Breyer, Sotomayor, Kagan, and Gorsuch joined. Only Thomas dissented, with Alito joining him. So this is a 7-2 opinion that held a person who's subject to deportation, but raises this claim of, I will be tortured if you deport me there, has the right to have a federal court review the factual basis as to whether they will be tortured. They can't get the federal court to review and do a de novo review of their conviction, the thing that's getting them deported. But in this 7-2 opinion, Justice Kavanaugh wrote a much better reasoned opinion than his dissent the other day in that California church case. In this decision, he wrote an extremely well written, well-reasoned view that immigrants, even criminal immigrants who are about to be deported, have the right to have a federal court review the factual basis. Now, in this case, this man convinced the hearing officer, the immigration judge, that he would be tortured if deported to Lebanon. And the judge believed him. And then an immigration review board, sort of an appeals process within immigration, didn't believe him. And then the Supreme Court didn't necessarily believe him. They just said the Court of Appeals gets to decide his case. Now, in this rule, in this part of the law, the 7th Circuit, which is Chicago, that's Illinois, Wisconsin, Indiana, and the 9th Circuit here in California and the other western states, they had the view that courts should be able to make these determinations. And all the other federal courts had ruled the other way. That's the best way to get a your lawsuit in front of the Supreme Court, when in one part of the country you win and in another part of the country you lose. And in federal law, it shouldn't matter where you live. You should win or lose under federal law, no matter which state you reside in. So I think there is some really good news there. And Justice Kavanaugh, Justice Gorsuch, he rules with Native Americans more often than most. Justice Kavanaugh wrote the opinion in last year's case that said there was racial discrimination in Curtis Flowers' 6 criminal trials for murder. That's where the DA kept excusing the jurors, coincidentally, the black jurors, again and again and again. And when they would convict this man in Mississippi, even the Supreme Court of Mississippi ruled that his rights had been violated. It took the Supreme Court last summer to decide you can't strike and remove from the jury in the initial stages all of the black jurors without committing racial discrimination against the defendant. And in that case, Kavanaugh wrote that opinion too, in another 7-2 opinion. So I just wanted to say that while Kavanaugh and Gorsuch may end up writing some opinions that we all disagree with very strongly, there is a sliver of good in even the writings of both Gorsuch and Kavanaugh, especially since we're stuck with them for a long time. They were both appointed very young, and as health improves in this country, as longevity improves, we're probably going to have those two for a very long time. If President Trump manages to win re-election, I suspect we'll have some more before January 20th of 2025. Things could get even better if you're a Republican, or much, much worse if you're of the Democratic persuasion. I wish I had more time. I'm just too talkative, and I could go on for hours. But if we have a couple of very easy questions, I'd be willing to answer 1 or 2 or 3.
Okay, well, thank you, Mark. So if you have any comments or questions, raise your hand or unmute yourself, and we'll try to get you on.
You ready?
I saw one hand. Mr. Ross, is it? Unmute there.
I didn't ask a question. I'm thinking.
Well, I'll start, Mark. Any prediction on Roe v. Wade?
Oh, I said years ago that everyone should prepare for Roe v. Wade's eventual overturn. President Reagan, recall, campaigned in 1980 on the prospect of, if I get elected, I'll appoint enough judges that'll overturn what was then just a 7-year precedent. It's now been, what, 40, almost 47 years since Roe v. Wade was decided. And although I'm not sure President Trump is anti-abortion, he does view some of his evangelical base as essential to his reelection, and he will continue to push for that. And I'm sure that Bill Barr, the Attorney General, will throw as much federal government support behind the eventual overturn of Roe v. Wade as possible. I predict it will get overturned, but there is some good news there. States can at least step in and do what they can to protect that right. But I still predict that it will get overturned. I'm not sure when, but I don't think the conservatives are going to rest until that happens. I just hope they don't go after all of the other well-fought, hard-won civil rights at the same time.
Okay. Anybody else? Ted, go ahead.
Ted?
Can you hear me okay?
Yes.
I can.
Okay. You know, many foreign countries have compulsory retirement at 72 or 75 for Supreme Court judges. How do we work that into our system?
Well, the Constitution says judges serve for life. So we need to either get the Supreme Court justices to agree to waive that, or we need to amend the Constitution. That is a practical matter. That's very, very difficult. But the other one is more personal to me. as I age, I keep thinking I get better. And I teach a lot of classes that have folks older than me in them, some of them in their 80s and 90s, who understand the material as well or better than I do, and who ask insightful questions that I couldn't think of on the fly. And thus, the idea of telling a federal Supreme Court justice, you've served for 18 years, you're done now, strikes me as problematic, because I don't want 40-year-old or 35-year-old or 30-year-old Supreme Court justices named, and I want older folks to be able to participate, because ageist as it sounds, I'm a little smarter now than I was 30 or 40 years ago. I've got more life experience and more wisdom. Now, it could be that when one reaches 95 or so, it's time to hang it up. And Justice John Paul Stevens did retire at the age of 90. He retired so that President Clinton, no, excuse me, so President Obama could name a replacement for himself. And then he went on a speaking tour and wrote more books between 90 and his eventual passing last year. But I don't want to tell somebody, oh, you're 72 or 75, you're past your prime as a legal thinker, especially since today's 72-year-olds are generally much more physically capable and mentally capable than, say, my grandmother, who at the age of 73 was completely gone. She suffered the dementia and Alzheimer's and all those things when I was just a young child at the age of 73. Well, today, as I approach the retirement age, I don't want to see any artificial limits put up. Maybe having them serve for a distinct term of years, maybe telling them you can serve for 15 or 18 years. Maybe that's the ticket, because then we wouldn't see the need to appoint 35-year-old judges who haven't experienced enough life yet and aren't wise enough, in hopes that they live 60 years and control for many, many decades. Maybe then if you have to retire after 15 years, well, we'd get people appointed at the age of 60 or 65, perhaps. But it scares me to try to say, oh, that person's too old and too out of it. Although it's entirely likely that President Reagan in his second term was too out of it to, say, be a Supreme Court justice. He may have been suffering from Alzheimer's. He eventually did admit Alzheimer's. And there's a lot of rumblings that by 1984, it was evident. But I don't want to set an artificial limit, just in part because I know hundreds and hundreds of people I'd like to see on the Supreme Court who are more than 75 years old, because I think they'd do better than some of the ones we've got.
Sheila?
Yes, I was wondering about the idea of expanding the membership of the court.
I still favor that. I tell my young credit students we should expand the Supreme Court, not just so we can win, not just so we could overturn mistakes of the past and flush away the conservative victories. We should expand the Supreme Court to more quickly diversify the court. It's still 6 men and 3 women. There's only one African American, Clarence Thomas, on the court. There's only one person of Hispanic descent, Sonia Sotomayor from Puerto Rico. It's not very diverse, and waiting for some of the 9 to retire or die to make it more diverse is a very slow process. So I look at it more as an affirmative action program where we could quickly diversify the court by expanding it to, say, 15, 13 even. The difficulty would be who's president and who is in charge of the Senate when we make that legislative change. Because remember, the number of people on the Supreme Court, as you learned in the Great Depression, is simply a matter for Congress. Congress and the president decide how many. And that's why, of course, FDR, he threw out the possibility of packing the court, expanding it, and raising it to some, I think they talked about 15 at the time, in order to overturn those decisions of those Republican appointees who were striking down the New Deal. I'm not in favor of simply expanding it so we can overturn those mistakes of the past. But if we couch it in terms of we need to make a more diverse court because we have a more diverse society, maybe that'll stem some future generation from saying, well, we need to make it 25 because we need to flush away all of those progressive decisions that the newly expanded 13 or 15 decided after Levick's expansion got passed. But I'm in favor of that, as long as we don't make it a political tit for tat where the next president and the next Senate will decide to make it even bigger, so they keep winning. I don't want to see that, because I don't want courts to become that highly political. Of course, we may be way too far down that road. We may already have a very politically charged court system as it is. Justice Roberts insists it's not. He says, we don't have Trump judges, we don't have Obama judges, we just have Supreme Court judges. Occasionally, even Gorsuch and Kavanaugh support him in that view. And Justice Roberts himself, he tries not to be a George W. Bush justice because Bush appointed him. And so there is, like I said, a sliver of good sunlight and good hope there that maybe they're not as political as we accused them of being. But when they overturn Roe v. Wade to satisfy those evangelical Christians, it's going to look very political.
Yes, Barbara, can you unmute?
I just wanted to say this has been an extraordinary hour with you, Mr. Levick. And if you're teaching at Pierce, I'd like to know what you're teaching.
I caught a little bit of that. It sounded like high praise, which I didn't deserve.
I can say it again if you'd like.
No, I caught enough of it.
I wanted to know well, I think you've done an extraordinary job of getting through some very complex material to people that may not have a legal background. So thank you for that. My question is, are you teaching a course at Pierce or someplace else that we should know about? Because I'd like to see you again.
Well, if you enroll as an Encore student on June 15, Monday, June 15, 2 weeks from today,
Yeah.
I will begin my Supreme Court seminar where we will talk for 30 hours over 8 weeks of various Supreme Court opinions from this term just being decided now that I find interesting or fun or controversial. And I'm also teaching the same class, but on a condensed view of that same class with the savvy seniors over in Calabasas. Now, I'm assuming that most of you folks are more Encino-based, and Pierce may be as far as you want to go. With Calabasas, we're doing Zoom there as well. It's not in person.
Well,
but those are the two places I'm teaching the Supreme Court this summer.
Are you limiting the number of people in the class? We have been going to Pierce for some time. Are you limiting the number of people in the class? And how many?
Only to the technical limit of 300. If you're on the wait list, you'll get in. And if you don't get on the wait list, but I've got room for you on the 300 limit, you'll get in.
Thank you.
The creative arts classes where John Paul Thornton assists students in painting or creation, nobody is going to want to have a professor with 300 pieces of art to critique and review. But with my classes that are going to be primarily lecture, and my view, with only a few questions allowed, the size of the class won't impact my education or the quality of the content. And so I'm going to let as many in until I can't let any more in. So if you become a Pierce student, you're already a Pierce student, sign up.
Yeah, and I can vouch for how interesting his classes are. He comes very well prepared, and the cases that are discussed are very interesting, and the conversation in the class is really good. Norma?
Yes, Gene.
Gene, go ahead.
When we were speaking of Roe versus Wade, I hope the Supreme Court justices are aware of her the movie was made on her dying deathbed almost, where 2, she admitted she never had an abortion, and 2, admitted she was well paid by the anti-abortion people to say what she said. She was paid well over $400,000 over the years. And this was a movie on, CNN or something, that she made on her almost dying bed. I was wondering if if our, I'm sorry, I lost my senior moment. I lost our speaker's name, was aware of this.
Mark Levick.
Mark, are you there?
I'm here.
Oh, were you aware of this movie?
Yeah, I saw the headlines about her deathbed change, and I saw some commercials for it. But her flip-flopping on that issue, I don't think is going to affect the right that was recognized by the justices in 1973. She was the plaintiff, of course, who brought the case anonymously. But I don't think her later in life saying, "Oh, I was against abortion," and then on her deathbed saying, "No, no, they paid me to say that." I don't think that's going to affect it, because there'll be plenty of other people who can stand up and say, okay, if I'm a person and I'm seeking an abortion and I have a right under the Constitution for all of the reasons listed in 1973. So I don't think that's going to have an impact on whether the Supreme Court overturns or not. I think the more important thing is going to be, how respectful will the Supreme Court justices, especially the Kavanaughs, the Gorsuches, and the inevitable future justices that will get appointed at some point, how respectful will they be of precedent, of stare decisis? We decided the case that way, and we have to keep deciding cases the same way. I fear they won't be very respectful. They went out of their way the last 2 or 3 years to overturn long-standing precedent that there really was no reason to overturn. In one case, they overturned a 50-year-old precedent because North Dakota really wants to collect sales taxes on people's Amazon purchases. And there was no good constitutional reason to overturn it other than North Dakota going back to the federal courts over and over and over again saying, we're not collecting sales taxes because our citizens refuse to pay use tax on the things they buy from out of state. And in that decision, the Supreme Court, for reasons I don't understand, overturned a 1967 case and said everybody now has to collect sales taxes if they sell things on the internet, even eBay sellers, who have never visited your state. And so their eagerness or their happiness at overturning old precedent in cases that weren't decided badly, they were decided fine. And there was no constitutional, we messed up in 1967. We should have decided it the other way. Their eagerness to overturn established law tells me that they'll look at the 1973 decision of Roe v. Wade and say, no big deal if we overturn that. It was decided wrongly, is their view. They're going to say, look, from the moment it was decided, everybody who is familiar with the Bible or goes to church knows that it was wrong. And I see Gorsuch and Kavanaugh leaning that direction. They've given hints that may be their view. And so I'm still going to hedge that Roe v. Wade is an endangered species. Now, I've been wrong so far on the one I predicted was even more endangered, and that was same-sex marriage. I really thought that the decision of Obergefell, that was 2015, I thought that one would be the first to go. After all, it's newer law. It's a much younger Supreme Court opinion. But hopefully, the justices will look and say, same-sex marriage is approved by the vast majority of the people, and there's no need to overturn a vastly popular civil right that's enjoyed by plenty of people. There's no need to overturn that just because a few conservative churchgoers say, well, that's wrong. At least that's my hope. I'd like to see most all of the civil rights that the Supreme Court has recognized remain.
Is there anyone who has a last question or comment? Yes, Lena.
With all these judges being appointed for life, is it possible for voters to recall them?
Not the federal judges. We can recall state judges if our state allows that. And the federal judges, the Constitution says they shall serve during periods of good behavior, which has been interpreted for 200 years now as a life appointment. Their pay can't be reduced. They can't be fired. They can be impeached by the House and put on trial in the Senate, but only for high crimes and misdemeanors. And while some might argue that overturning Roe v. Wade is a high crime or misdemeanor, I don't think that'll be a winning argument. And so the standard for removal, I think several federal judges have been impeached and tried and convicted and removed. We've never had a successful impeachment and removal of a Supreme Court justice because they serve for life and they generally are somewhat well behaved. So I think we're stuck with them.
Len, did you have a question?
Just curious, does that include emotional instability? Is that a reason for impeachment?
I don't think that constitutes a high crime or misdemeanor. The 25th Amendment, where the president loses the ability to function in the office, that applies only to the president and not to all the other officials. I don't think there's anything that would allow the House to vote to impeach even a federal judge whose dementia and Alzheimer's has overtaken them. I think we're still stuck with them. Hopefully, since they get paid even if they stay home, hopefully they'd resign when it was convenient for them, so a member of their own party could replace them. As a note, that's why I'm really still angry with Justice Ginsburg. Oh, she could have for several years there had herself replaced by President Obama in the early years. And President Obama could have found, someone that was just like Justice Ginsburg, but so much younger and in better health. I hope she hangs on. But that's why John Paul Stevens decided to retire and step down. He still got paid, but he stepped down because he wanted President Obama to be able to replace him because he was looking forward to what happens if another President Bush wins. And John Paul Stevens, remember, was an antitrust lawyer whose family had started not the Palmer House, but the Chicago Hilton. He came from money, and he was a Republican. And President Ford named him to the Supreme Court, but over the years he shifted to believe in the rights that the progressives espoused. And thus he wanted to step down not when a Republican could replace him, but he stepped down intentionally so President Obama could replace him. Anyone else?
There's one last quick question, Mark. Is there a minimum age requirement for a Supreme Court justice?
I do not think there is, no.
So you could be
35
nominated.
to be president. You've got to be 35 to be president. You got to be 30 to be a senator and 25 to be a House member. But I think most of our Supreme Court justices have been to law school, but that's not in the Constitution. And most people get out of law school when they're about 25 if they've gone straight through. But no, there's no minimum age. At some point, somebody well-connected who's only 30 years old is going to be nominated. One would hope the Senate would reject them even if they're in the same party and say, no, a Supreme Court justice simply has to live more life than only be 30 years old. We need someone who's got the wisdom that you usually pick up with getting to age 50, say.
Well, Mark, I want to thank you on behalf of our Hazak program. Thank you very, very much for an excellent program and discussion, and maybe we'll look forward to hearing from you again in the future.
I'd be willing. Thank you all. Thanks for everyone.